I'm Matt Gishard, and this is No Holds Barred. In this episode, I'm going to get back and talk a little bit about Stand Your Ground. We've spoken about it previously. We're going to talk about it again. Stand your ground. It's an important concept in the law. It's been around for years and years and years. And I want to talk about it again because I want to make it clear that it's good law, and it's law that's been in the state of California since 1942. And I've often cited a case, and if you'd like to look it up yourselves. So there is a case that goes all the way back to 1942, and it's People versus Hatchet, and it is a stand your ground rule. And it's a case in which a woman was in her kitchen. She was confronted with potentially serious bodily injury or death, and instead of leaving her kitchen, she stood there and defended herself. And at that time, in that case, the trial court said she could more easily have left, and she should have left. And that case went up to the Court of Appeal, and in California, 1942 Court of Appeal case held that you may stand your ground. And now our law is very well defined, and it's been around for a number of years. And not only can you stand your ground, but you can pursue your assailant until you believe you are in a position of safety. And if you look at 505, justifiable homicide, self-defense, or defense of another, those are jury instructions. That's precisely what a jury gets. So let's talk about how that actually works in real life. We talk about the castle doctrine, where somebody is inside their house and they can defend themselves, and there's an enhanced ability to defend yourself. But we often hear somebody saying, oh boy, if you shoot somebody out in your front yard, you better drag them back in your house because then you get the castle doctrine. Absolute nonsense. The fact of the matter is you have a right of self-defense, and you may stand your ground, whether you're in a public park, whether you're in your front yard, whether you're in a sidewalk, anywhere. If you perceive that you're going to reasonably perceive that you're going to suffer death or great bodily injury, you have a right to defend yourself. And that's our self-defense statute. And it must be reasonable. It must be reasonable. In fact, if you see somebody who has a gun, you perceive that, and an objective person looking at it would say, absolutely, they're going to suffer death or great bodily injury, and they reasonably fear that. Then you have a right to defend yourself, and you have a right to stand your ground. The difference about standing your ground, and we often talk about in the law, retreat states and no retreat states. So what does that mean? Retreat state means if you can more easily get away or retreat, or in the case that I talked about at the start, go out the kitchen door and run away, you can more easily do that. You're required to do that. No retreat states, such as California, and now most states in the United States, are no retreat states. And why would that be? Well, because in a split second, a person has to make a decision. Okay, I guess I'm going to try to get away. And they're running out and they get shot in the back. No, it's not reasonable to expect that they will try to get away. They may not get away. Stand your ground, defend yourself, and you have a right to defend yourself. Several months ago, I saw a news article on one of the states in our union the legislature passing a stand your ground. And the press article was quite distressing about, here's another one of these crazy right-wing states doing the stand your ground. Well, in fact, there's nothing right-wing about any of it. It's reasonable law and makes an awful lot of sense. If you recall the Trayvon Martin and Zimmerman case in Florida, I believe, That wasn't a stand your ground case. That was a self-defense case. That's what the jury found. Those two individuals at some point got into a fight and were rolling around, and Mr. Zimmerman shot and killed Trayvon Martin, and people were quite distressed about that, and rightfully so in some cases. But the idea of the stand your ground came up in the case, and that was not a stand your ground case. It was a self-defense case. That's ultimately what the jury determined. But again, stand your ground is a good concept in the law. It's something that is reasonable, and it's been well thought out. And in fact, every single murder case that I'm aware of in the state of California, where someone brings up self-defense, the jury gets that instruction on self-defense and stand your ground. And they've been getting that instruction since shortly after 1942. With respect to stand your ground and self-defense, it's interesting that if the issue of self-defense comes up, then the judge has a sua sponte duty. That means he's required to do it, even if one of the attorneys for the defense doesn't ask for it. If any issue comes up of self-defense, the judge must give a self-defense instruction. And in fact, then the burden switches to the prosecution to prove beyond a reasonable doubt that it's not self-defense. So picture a murder case in which somebody believes that they have a right of self-defense, but it's unreasonable. Just recently, a case that I read was an individual in some state, I forgot where it was, saw somebody walking across the street towards him. Now, this individual had a gun. The citizen had a gun, and here was somebody walking across the street towards him, and that citizen said, I believed he had a gun, I felt threatened, and he shot, and he actually killed him. I don't know if you recall that recently. That, in fact, was unreasonable. The person walking across the street did not have a gun and was in no way a threat to the citizen who claimed self-defense. In fact, it was a tragic accident. And in that case, we would often talk about imperfect self-defense. It is unreasonable what his thought was, but rather than being a first-degree murder, it was a manslaughter. What's a manslaughter? We'll talk about an intent to kill in this situation without malice, and a very tragic case, but imperfect self-defense. So in that case, had that case gone to a jury, I would have expected that the jury would have found that imperfect self-defense, and they would have gotten a self-defense instruction because the judge would be required to do that, but finding that it was unreasonable, and in fact, he did not have a right to exercise self-defense. I suppose the moral of the story is, please, if you have a weapon, be very, very careful. The smartest thing in the whole world, if you feel threatened, is call the police. However, if you're in imminent, reasonable belief that you're going to suffer a death or great bodily injury, and again, reasonable belief, well, then you have a right of self-defense. Otherwise, you do not. If you enjoyed this episode, please hit the like button and hit the subscribe button. It really helps us with the YouTube algorithms. See you next time on No Holds Barred.